Good morning. I'd like to call to order this meeting of the Assessment Appeals Board number 2 for May 9th, 2016. The time is 9:30 a.m. I'll now take a roll call of the board members present. Board Member Hess.
Present.
Board Member Little.
Present.
Board Member Sisk.
Present.
All right, please stand for the Pledge of Allegiance. Repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Next, we'll have the ceremonial swearing in of Assessment Appeals Board number 2 members.
Good morning, board members. I'm Brian Palmer. I'm your Chief Deputy Clerk of the Board. If you'll all rise and raise your right hand and repeat after me. I state your name.
I, Pat Little,
Do solemnly affirm that I will support and defend
do solemnly affirm that
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully
and I will well and faithfully
discharge the duties upon which I am about to enter.
discharge the duties upon which I am about to enter.
Excellent. Thank you very much.
Thank you.
I'll hand these to your clerk if you'll all sign your documents.
Thank you.
Thank you so much.
Thank you.
And as this is the first meeting of Assessment and Appeals Board number 2, our next item is item number 4, election of the chair and vice chair to Assessment Appeals Board number 2. The terms will expire on July 17th, 2017. An annual election of chair and vice chair will be made thereafter at the annual meetings of the Assessment Appeals Board. Normally, the chair and vice chair would be elected at the annual meeting, but your first one is only 2 months away, so we're basically extending your terms until the 2017 annual meeting so that you're not only chair for 2 meetings, basically. So we would first start with a nomination of the chair to Assessment Appeals Board number 2.
I nominate Mr. Hess.
Give me just a second. All right, are there any other nominations for chair? All right. So do we have a second to Ms. Little's appointment of Mr. Hess as chair?
I second that.
All right, if the board members can vote on that election, please. All right, Mr. Hess is now chair. Now we need a nomination or motion to approve a vice chair.
Motion to approve Mr. Sisk as vice chair.
Seconded.
No, mover is
All right.
Pat Little.
Oh, sorry about that. I really screwed that one up. Give me just a second. All right, sorry about that. Please vote.
Okay.
and Mr. Sisk has been elected as vice chair. If we want to go ahead and just take a second and move Mr. Hess to the middle, Mr. Sisk, you're fine, whereas just Mr. Hess and Ms. Lilla can switch.
Ready? Chairs.
Thank you. I'm not sure.
You do.
Thank you. Go ahead and hit the sign in.
Okay.
Thank you. Chairman Hess, you may now take over if you would like, being with item 5, where you can direct the clerk to announce all items for you. That is at your discretion.
Absolutely. Go for it.
Okay, next we're at item 5, adoption of the 2016 Conflict of Interest Code for Assessment Appeals Board number 2.
Yes, I've reviewed them, and I move to approve.
I reviewed them and I second them.
As did I.
Please vote. All right, thank you. The Conflict of Interest Code has now been adopted. All right, next is item 6. We will now administer the oath to all members of the public that will be giving testimony to the board today. If you could please all stand, I'll now place you under oath. When I've completed reading your oath, you'll state I do. Please raise your right arm. You and each of you do solemnly affirm that the testimony you're about to give and the matters now pending before this board will be the truth, the whole truth, and nothing but the truth. Thank you. You may now be seated. Item 7, agenda review. This is for the board to consider and approve by majority vote any minor revisions to the board items and or attachments, and any item there added there to or removed continued from the Assessment Appeals Board agenda. Let's see. All right. Agenda review for May 9th, 2016. The clerk of the board recommends agenda review by the Assessment Appeals Board. The agenda review consists of the following agenda items. Item number 71. Application number 15-10005, applicant Anita Lashkari, continued to June 13th, 2016, pending receipt of original stipulation. Item number 73, application number 15-10069, applicant Alberto Mendoza, denied due to lack of appearance. Item number 75, application number 15-10117, applicant Ernie H. and Jean E. Sandlin, continued to June 13th, 2016, pending receipt of original stipulation. Item number 76, application number 15-10123, applicant Brian Shaw, denied due to lack of appearance. Item number 77, application number 15-10135, applicant spelled the first name Shangdan, last name Zhou, continued to June 13th, 2016, pending receipt of original stipulation. Items 79 and 80, application numbers 15-10302 and 15-10303. Applicant Howard Stern, continued to June 13th, 2016, pending receipt of original stipulation. Item number 81, application number 15-10319, applicant, I'll spell the first name Navabeh, last name Borman, denied due to lack of appearance. Item number 82, application number 15-10503, applicant 6100 Condor LLC, Craig Marcus, continued to June 13th, 2016, pending receipt of original stipulation. Item number 83 through 84, application numbers 15-10570 and 15-10571, I'll spell the applicant's first name, Rajeev, and Christabel, last name Narula, and that one is denied due to lack of appearance. Item number 86, application number 15-10890, applicant Jamie Juarez Jr., denied due to lack of appearance. Item number 87 and 88, application numbers 15-10921 and 15-10923, applicant Salvador S. and Georgina M. Toledo, denied due to lack of appearance. Item 89 through 90, application number 15-11160 and 15-11162, applicant Jason and Stephanie Beaton, denied due to lack of appearance.
Mr. Clerk, on that last one, you misstated the first number. It should be 15/11161 instead of 60.
Oh, that's correct. I apologize for that error. So, all right. So now we are looking for a motion to approve the agenda review.
So moved.
I second.
And you should be able to click motion on your screen and now second. Does that work?
Yeah.
Thank you. And if the board members could vote. Thank you. The agenda review is approved. All right. Item 8 is public comments. This is time for citizen comments regarding assessment appeals related matters not on this agenda. I don't believe we have any speakers. I would just comment that the California State Board of Equalization is holding its second 2016 Taxpayers Bill of Rights hearing on Tuesday, May 24th, 2016 at the State Board of Equalization's office in Sacramento. The clerk of the board has more information on that if any taxpayers wish to address the State Board of Equalization. And item 9 is board comments. Do any of the board members wish to make comments?
Congratulations to our
thank you.
new chair and vice chair.
Congratulations, Lee.
I don't believe there are any.
All right. And Mr. Chairman, would you like me to continue reading the agenda items?
Sounds like you're rolling. Let's
All right.
continue.
Next, we have items 10 through 15, application numbers 13-12180, 13-12182, 13-12183, 14-11242, 14-11245, and 14-11246 for applicant Baxter Healthcare, represented here by Versatax Consulting Incorporated. This is a request for approval of a large value stipulation agreement. It has been provided to the board as of Thursday by email, along with a follow-up memorandum sent to the board by email on Friday afternoon. So this is up for discussion, questioning, or approval or denial or whatever the board wants to do with it.
Excuse me, Mr. Chair. May I please read from the Apple Code section dealing with waiver of penalties for the board's background information?
Absolutely. Please.
I'm looking at Revenue and Taxation Code section 463, subdivision C, and it says, if the SSC establishes to the satisfaction of the County Board of Equalization or the Assessment Appeals Board that the failure to file property tax statements within the time required by section 441 was due to reasonable cause and circumstances beyond the assessee's control and occurred notwithstanding the exercise of ordinary care in the absence of willful neglect, it may order the penalty abated, provided the SSE is filed with the county board written application for abatement of the penalty within the time prescribed by law for the filing of applications for assessment reductions. I just wanted to give that as background information to the board for considering various stipulations coming before the board today.
Thank you.
Thank you, Ms. Porsche. So it takes do we need to hear anything from anyone? Or?
It's up to the board. Apologize. It's at the discretion of the board. These are, I should mention this is a large value agreement, meaning it's over $5 million. These are put on the agenda so that as special items so the board can examine them. question the assessor's office if they wish to. The applicant's representative is also here today in case the board has any questions or if the board wants to have a discussion before approval. And it's at the discretion of the board what they want to do with this stipulation.
We've been supplied these over email, and I've reviewed them, and I don't have any items that need clarification. So if you're ready, I can make a motion.
Do you have anything? You
No,
ready to
I'm
proceed
ready.
with
I
it?
reviewed it. I'm okay.
Move
The
to
assessor's
approve.
office have anything they want to say? Probably
The
not.
assessor's office has no comment.
I did appreciate getting the good cause memorandum, so
Yes.
thank you.
I move to approve.
I second.
If you could click
Yes.
so on your screens. Sorry, getting adjusted. It's been a while.
Okay.
All right, and please vote. All right, that motion passes. The stipulation has been approved. Next is item number 16 through 21. Application number 13-12181, 13-12184, 14-11243. I typed that number twice. I apologize. And then 14-11244 and 14-11247. The applicant's representative has requested that the board endorse or approve or accept, I don't know what the proper terminology is, the withdrawal. The withdrawals technically aren't final until the board accepts it, and so they're asking, normally the board doesn't approve them, they're all just considered withdrawn. In this case, they wanted the prior stipulation approved before the withdrawal was entered into the record, so we're just looking for the board to, I would guess, make a motion to accept the withdrawal of the stated applications.
I so move.
Second.
It's been moved and seconded.
And please vote. Thank you, that motion passes. Next, we have item numbers 22 through 30. Application numbers 14-11691, 14-11693, 14-11695, 14-11697, 14-11699, 14-11702, 14-11703, 14-11704, and 14-11705. The applicant is Fresh and Easy and Y-OPCO LLC. This is a request for approval of a large value stipulation agreement. As with the other one, this also includes abatement of penalties. It's up for discussion and or questioning and or approval by the board.
No question.
No comments.
Lacking any discussion, board's looking for a motion.
I so move.
Second.
It's been moved and seconded.
Please enter that with your computer terminals. Thank you. Please vote. And the stipulation has been approved. Next, item 31 through 70, application numbers 14-11249 through 14-11258 and 14-12056 through 14-12085. Applicant is Charter Communications. This is another request for approval of a large value stipulation agreement.
No
Any
comments.
discussion?
No discussion.
No
Move to
discussion.
approve.
Ms. Little moves to approve,
I second.
seconded by Mr. Sisk.
Please vote. One more vote needed. Thank you. That stipulation has been approved. Thank you, Mr. Daza, for appearing here today to speak about those if needed. I believe we've approved all your items.
I wanted to say good morning, board members. That's all I guess. All right, thank you so much.
Cutting edge argument.
All right. Looks like next we're on to item number 72, application number 15-10026. Applicant Terry M. Supple Family Trust, and Terry Supple, represented today by Mr. Michael Supple. If you please come forward to the podium. There was no confirmation of appearance submitted on this case. I spoke with the applicant's son, who is here today, last week, who indicated he will be here to request continuation. So,
Have there been any prior continuances?
no, this is the first hearing for this case, so it has had no prior reschedulings or considerations by the board. Therefore, it would be eligible, and because confirmation has not been turned in, it wouldn't necessarily be eligible to move forward today. We did not receive 30 days notice of hearing. So at this point, and I apologize, we're a little backward. Normally, the chair would ask the applicant to state their name and what their intentions are here today.
All right, so we're going to go backwards. Would you state your name for the record?
A little hard to hear you.
Would you state your name for the record?
Michael Sean Supple. I'm the son of Terry and Sandy Supple. My father passed away about 3 months ago, so that's why
Sorry.
there's a little bit of this delay, and he was kind of moving ahead with the whole appeals process.
All right, sorry to hear that. And your request today is for what?
A continuance? Is that what I'm asking for, to get another date?
Do we have a suggested date from the assessor's office, or?
Good morning, Brooke Hill, representing the assessor's office. I believe Mr. Vlahakis is suggesting 8/29 or 10/24.
Yes, at this time, our recommended options would be August 29th, 2016 or October 24th, 2016.
Is that being put to myself?
Right, so it'd be whichever works best.
Oh,
for
the
you.
August would be fine. August 29th?
And does the assessor need any data provided by the applicant within a certain time period?
The assessor would just request that the applicant speak to Mr. Denham in the back of the room before you go home today.
Okay, thank you.
Thank you.
All right. So at this time, we'd be looking for the board to make a motion to continue this case to August 29th, 2016.
So moved.
I so move.
It's been moved and seconded.
I second.
Please vote. And that motion passes. The case has been rescheduled to August 29th. We'll see you then.
Excellent. Thank you very much for your time.
Thank you.
Okay, it looks like next we have item 74, application number 1510070, applicant William Mondras. And I believe he's present. Come up to the podium, please.
Morning, sir. Would you state your name for the record?
Yeah, I'm William Andrews.
And what are you requesting of the board?
I transferred part of the property over to my sister because I owed her money. And then it was transferred back, and I paid her the money in cash, okay?
We don't want to hear the case.
But they raised it. We've had Prop 13 taxes since for 21 years.
I'm going to interrupt you just for a second. What specifically are you wanting the board to do with your case today?
To take the increase, they made it from $2,500, which I was paying last year, and then they raised it to $4,300. I would like the board to put it back to $2,100 again because it was a mistake. I didn't know that there was a tax consequence as a result of transferring the property, and nobody in the assessors board told me that there was a.
So I assume you're looking for a hearing date to have that issue resolved? You're looking for a hearing date? You're looking for a hearing date to have that matter heard?
I'm sorry, I'm a little hard of hearing.
You're looking for a hearing date to
This
have
is
that
the
heard?
hearing, isn't it? This
Well,
is the.
is the assessor's
If I could
office?
maybe provide a little clarification.
All right,
The
please.
assessor has tried to contact Mr. Mondras several times. We were finally able to speak to him late last week. We're not prepared to move forward today. We would like an opportunity to discuss with the applicant further. This case is assigned to Mr. Ekema, and I can give you his card. He's on leave this week, but I can have him contact you first thing next week, and you can discuss this case with him and hopefully resolve it prior to any future schedule. hearing.
I'm sensing he did not hear you.
Can you,
The assessor's office is not ready to proceed today to a hearing. They'd like you to talk with Mr. Ekema of the assessor's office between now and when.
He refused to see me.
I'm sorry?
He refused to see me.
We'd be happy to set up an appointment for you to come in and sit down and discuss. It'll have to be next week.
Well, they're wanting to talk to you now. Can we have you talk perhaps with Ms. Hill next break and work this part of it out?
Yeah, I called him several times, and he refused to see me. I purchased a house for my daughter
I understand.
21 years ago, and I can understand that, it would jump for 1 year, but it should go back to Prop 13 taxes. It's not forever.
I understand your position, and you'll have a chance to explain that at a actual hearing date other than today. But the assessor's office needs time to prepare, and they want to talk with you and hopefully resolve it before we have to go to a full hearing. So do we have a suggested continuance
The assessor
then?
would request a continuance to August 9th or
29th.
October 24th.
Okay.
Sorry, October.
August 29th or October 24th.
Mr. Mandris, which of those two dates would work for you? Well,
29th. We have August 8th if you want.
October.
No, we'll meet with you next week, but to continue the hearing, to come back to the board, we can continue to this date or this date. 8/29 is fine.
All righty, so we're looking for a motion to continue this matter, number 74, to August 29th.
I so move.
Mr. Ekema will call you next week.
Mr. Sisk moves. Ms. Little seconds. The motion to continue this matter.
And please vote. Thank you. That motion passes, and the item has been continued.
So we'll see you back here on the 29th if you haven't resolved it.
All right, let's go ahead and call up item number 78, application number 15-10152, applicant Jeffrey G. and Felipe R. Ith, the Ith Family Trust, represented by Felipe Ith. Sorry.
Good morning.
Did we pronounce that right?
Philippa Ith.
Okay.
Yes.
Before we proceed, Mr. Chair, I will abstain from any voting. I was a former neighbor of Jeff and Philippa.
All right. Again, you stated your name for the record, so what is it you're requesting?
I'm requesting a brief continuance for additional information for the assessor.
Yes, Mr. Chairman, this applicant unfortunately did not submit their confirmation of appearance 30 days prior to the hearing, so the applicant would be, regardless, required to continue the case to a later date. Our options for continuance are August 29th or October 24th.
Does the applicant have a preference?
The earlier, the better. Did you say you had August 8th? Did I hear you say that earlier?
If we can, if August 29th won't work, but we would prefer August 29th over August 8th.
Well, you never want to make the clerk unhappy.
You know what? No. I just realized, to avoid a conflict of interest with Miss Little sitting on the board, it would be better to go to August 8th, where Miss Little will not be sitting on the board. So I would recommend August 8th if that works with everybody.
Thank you. Thank you. It all works out.
Does that work for the assessor's office?
Yes, it does.
All right, so we're looking for a motion to continue it to August 8th.
I so move.
Other side. I guess do I get to second my own?
Yes.
Second as well here? All right, I'm sorry. Seconded.
Are you able to click the second
Oh,
button?
oops.
Sorry. Thank you. Please vote. That motion passes 2-0 with Board Member Little abstaining.
All right, thank you. Thank you for coming.
Thanks, Matt.
All right, 85 is our next item. Application number 151088A. Applicant is Janet, spell last name Simeone.
Would you state your name for the
Good
record?
morning. Janet Simone.
Good morning.
Good morning.
And what is it you're requesting of us?
A continuance on this hearing.
Yes, Mr. Chair, this item also is a non-confirmation of appearance 30 days prior to a hearing, so the applicant would be required to reschedule at this time. Again, our date options are August 29th or October 24th.
Does the applicant have a preference?
August 29th would be fine.
Is that okay with the assessor's
That
office?
works for the assessor, yes.
All right, so we're looking for a motion to continue item number 85 to August 29th, 2016.
I so move.
Second.
Moved and
Thank you.
seconded.
Thank you. That motion passes 3-0. All right.
Thank you, ma'am.
Sorry, just a second. And it looks like our next item is 91 through 93. Application numbers 15-11306 through 15-11308. Applicant J. Dunlap. No confirmation of appearance was submitted on this case, therefore continuance will be required.
Good morning. You state your name for the record?
Good morning. I'm Marilyn Rogers, the wife of Jay Dunlap, and I'd like to request a continuance.
All right, you've heard our continuance dates. Do you have a preference?
August 29th is preferable, if there's any available slots.
All right, and assessor's office have any problem with that date?
August 29th is fine. We would just request that you speak to Mr. Denham. I think he just stepped out.
Yes.
Thank you.
Thank you, ma'am.
All right, so we're looking
Thank
for a
you.
motion to continue the items 91 to 93 to August 29th.
I so move.
Second.
Moved and seconded.
And that motion passes 3-0.
Thank you very much.
All right, that completes our regular agenda. Next, we'll have our amendment requests agenda, starting with item number 94. I'll just preface all the amendments as there are certain things that the applicant is allowed to amend after the applications are filed, all of which require approval by the board. The clerk has pre-screened all of the following amendments and believe that they are appropriate and that it would be acceptable for the board to approve them. But as the board is required to approve any such amendments, we will cover each one individually. The first amendment request is item number 94, application number 15-10849 for applicant VTR Grand Oaks LP, Brian Wood, represented by Equus Property Tax Service, David Dodd. Let's see. They are not present today. However, we are not sure if amendment requests actually require that the applicant's representative be present. Therefore, we would request the board review the letter submitted by the taxpayer's representative and determine if they should approve it or not. I'll go ahead and hand that out now.
All right.
It is council's opinion that if the letter sets forth the relief requested, that the board may entertain the request from the applicant if the board believes it has sufficient information from the letter.
As laid out, and here's the application submitted by the applicant's representative, and attached is their request for amendment dated January 20th, 2016. They are requesting to amend the application in section 6 to select box B2 for the change in ownership date of August 8, 2013. What this amendment does is it allows the board to hear and decide the base value of the property on this matter. The applicant does have additional appeals that they actually filed this week on file for the base year value. I did speak with the applicant, and they still wish to amend this application so that they have a protective application. So ultimately, they may end up withdrawing this application, but they'd still like the board to amend it so that they can keep it open protectively to cover their base year value. So at this time, the request is for the board to approve an amendment to Section 6 of the application to select box B2 for the change in ownership occurring August 8, 2013. Before the board makes a motion, I'm not sure if there's any comments from anybody on the matter.
I see no one coming forward. Anything from the assessor's office?
I would just comment that an assessment rule change was issued on this property, changing the base year value from $28.8 million to $56,303,000. And I believe that the application should also be amended to include the amended base year value.
The applicant didn't necessarily request the value be amended. The value on the roll is not required to be accurate for the board to, as listed on the application, is not required to be accurate for the board to address it. So I don't necessarily know if that amendment matters. We constantly get applications with wrong roll values. So what really matters for the board to hear and determine the base year value is that Section 6B2 be selected. If the board wishes to update the roll value on the application as well, they can. I don't know how appropriate that would be without a request from the applicant, though.
I believe it's at the discretion of the board.
Mr. Chair, I'm a little uncomfortable changing anything further on the application without the applicant being here and physically agreeing to it. I know we have the right to, but that can be addressed in the hearing as well, right?
Yes.
Is that all right with the assessor's office? Doesn't put you in a poor position? Doesn't put you in a position you don't want to be in?
I don't believe so.
All right.
That should be fine.
As I said, the taxpayer is now just going to keep this application open protectively. They actually get greater relief by challenging their base year on the appeals they filed this week that goes back to, I believe, 2013. So this application probably isn't going to end up mattering, but they'd like to include the base year in it and keep it open just as a protective matter.
So it looks like the board is, chair is looking for a motion to approve the amendment as requested.
So moved.
I second.
Board members, please vote. Thank you, and that amendment has been approved.
Mr. Chairman, I'd like to clarify, when you made a statement to approve the amendment as requested, you were referring to the request by the applicant?
The request by the applicant, correct.
Thank you.
And mover and second,
Yes.
understand that as well?
Yes.
All right.
All right, next we have, item number 15. I'm getting my tongue tied today. Item number 95, application number 15-11233 for applicant Bolt Enterprises, LLC. This is also a request for amendment. I will hand out the application and the request to the board.
Thank you.
Thank you.
All right, and we do have the applicant here, so I think it'd be best if they explain their request themselves.
Good morning. You want to identify yourselves for the record, please?
My name's Ed Shillow, and this is Mr. Bolt, the owner. Good morning.
Good morning. You want to go ahead and explain what it is you're requesting?
What we're requesting is that in the consideration of the property value this year, that we also include consideration of some construction additions that were made in the prior year to determine, and what that was done with was on a supplemental assessment. And we'd like to include that supplemental assessment in the consideration of the value for this year.
For the board, I'll clarify. The applicant can only appeal their supplemental assessment within 60 days of issuance, but they can appeal what's called their base year value within the first 4 years of the supplemental assessment being issued. So based on the applicant's written request, they're requesting to amend the application in section 6 to select box C, subsection 2, to protest the base year established for new construction. The new construction value was established September 1st, 2014. So that request is for basically for their construction base value, and any relief would apply 2015 forward, which is the rules under filing a prospective base year appeal.
Any commentary or opposition by the assessor's office?
The assessor has no problem with the amendment and agrees that it would be a prospective base year value appeal.
All righty, so it looks like we're looking for a motion to approve the applicant's amendment.
I
request.
so move.
Second.
Moved and seconded.
Please vote. Right, now the board has the option to take no further action, at which time the clerk would schedule a valuation hearing for a later date, giving the applicant a minimum of 45 days notice, or the board can make a motion to continue the case to a later date for the valuation to be heard. My recommendation would be that the board takes no action and lets the clerk schedule the matter as if the application were just submitted and put it through the process, but the board is free to pick a date now if they wish.
And the applicant will get all the notifications.
Correct. If the board takes no further action today, we would notice the valuation hearing as a new hearing, giving the applicant 45 days notice, and both the applicant and the assessor the opportunity to use their one-time right to a postponement of the hearing should they so desire. So I don't know what the applicant is necessarily requesting or what the board wants to do. My recommendation would be that the board does not set the valuation hearing at this time.
Is that, if we were to take that action of not setting a specific hearing date at this point, would the applicant have any problems with that?
No, we wouldn't.
So it sounds like the board is going to take no further action. All right. Your amendment has been approved, and you'll get notice from us sometime in the near future of the valuation hearing. So you're all set.
All right. Thank you, gentlemen.
All right. Next, we have item number 96, application number 15-11309 for Wells Fargo Bank N.A., Las Posas Plaza LP, Lessor. This is an amendment hearing, and I'll go ahead and the same situation is going to apply to item number 97, but there's slightly different applicant names. Let me go ahead and hand out the applications first.
Thank you.
If the applicant's representative would like to explain why they're here today.
Yeah, sure. My name is Gregory Dibney with Ryan LLC. We're representatives of Wells Fargo Bank. For item number 96, Wells Fargo Bank is the lessee and Las Posas Plaza is the lessor. We mistakenly filed the application in the name of the lessor. Wells Fargo Bank pays all of the taxes and therefore is able to contest the property taxes. We should have filed in the name of Wells Fargo Bank. We're requesting that that applicant name be changed to Wells Fargo Bank N.A. As for item number 97, World Savings and Loan Association was acquired by Wachovia, which was then acquired by Wells Fargo Bank, and we should have filed in the name of Wells Fargo Bank N.A. for that one.
board members, I'll just give you slightly more information. This came across the clerk's radar because we compare agent authorizations to the applications to make sure they're in compliance with the property tax rules. The agent authorization is attached here as page 3, as you'll see. That was executed by a corporate officer of Wells Fargo, and the application was in the names of Las Posas Plaza and World Savings and Loan. When that came to our attention, we requested clarification from the agent, at which time he quickly clarified that Wells Fargo Bank was the proper applicant and that it was simply an error on the application. And therefore, as the authorization is required to be valid at the time of filing, it wouldn't necessarily be appropriate for the authorization to be revised. Therefore, because the applicant can correct the applications, we recommended that the applications be corrected. It was determined in a prior Superior Court case that was determined here in Ventura County that the agent or applicant does have the right to amend the applicant's name or correct the applicant's name when the wrong one has been listed on the application. Therefore, the clerk's recommendation would be that the board approve the requested correction, which is to correct the applicant name to Wells Fargo Bank in A.
Council would only have one added comment. The prior Superior Court case dealt specifically with the unique facts of a specific case. So I don't believe that that is actually precedent that's applicable here, but I do believe that it is appropriate for the applicant to correct the name on the application as long as Wells Fargo is the entity actually paying the real estate taxes.
Thank you, Counsel. Assessor's Office, have any objection?
The assessor has no objections to the applicant's request.
All right, so we're looking for a motion to accept the amendment requests as to items number 96 and 97.
I so move.
Second.
Moved and seconded as to both number 96 and 97.
Thank you, and that passes. And although the screen only displays item number 96, I will fix the record after the fact to show that your action applies to both 96 and 97.
Thank you for your time.
Thank you.
And that completes our amendment requests. And thank the board for your patience on that. This is the first hearing where we have 2015 applications scheduled. Therefore, we're kind of using this first hearing as a cleanup hearing. Next, we have validity hearings. So the first validity hearing, these are applications the clerk deemed invalid as not meeting requirements of Property Tax Rule 305 and rejected, and the applicants have challenged the rejection. So we'll start with item number 98, application number 15-11071, applicant Jose Montoya, represented by Angelina Montoya. I'll go ahead and hand out the I'll hand out first the applications, and then I'm also going to hand out reference copies of the board's policy on filing applications after the deadline, as well as all the property tax rules related to timely filing of appeals. And the applicant has provided, is this?
Excuse me, Mr. Clerk, I didn't notice, was the applicant also provided a copy of the background materials?
No, we don't typically do that. It's just the codes that are in law for the boards to reference, so we don't hand those out to the applicant.
I believe just for due process considerations, I'll give my copy over to the applicant so that the applicant follow the conversation, and I'll share with board member Little.
This is just a copy of the guiding regulations. And the applicant has also provided an exhibit. I'll go ahead and hand that out. I've given the board a copy of the application as well as the validity hearing notice, at which I've highlighted on the validity hearing notice what the board is going to determine. The clerk has determined this application is not timely filed. As you'll see, it is date stamped September 16th, 2015. The deadline to file appeals for the 2015 filing period was September 15th, 2016. Our office was open until 5 p.m. that day. Applicants could also mail in their applications and get it postmarked by before the post office closed that day. This application was submitted in person by Ms. Montoya on September 16th, 2015. She walked it into our office. We informed her she was late, and she wished to challenge that and try to ask the board for acceptance to file it late. I made the applicant well aware that the board does not have any jurisdiction to accept late filed applications. And so under all the rules and board policy, the board is not permitted nor has jurisdiction to accept applications filed after the regular filing period deadline when it's a regular appeal for the regular assessment. Therefore, the clerk's position is that the board should reject this application or deny this application as it is untimely filed. And the applicant is here to say anything that they would like to say.
Ready to proceed? Now, I've looked, I don't know about the other board members, but I've looked through the informational packet that's been handed out. I don't see anything that gives us the authority, unfortunately, to do too much, but I'm going to look to council to see if I'm correct in looking and seeing that.
I believe the chair's assessment is appropriate, primarily based on Revenue and Taxation Code Section 1603, Subdivision B1. It provides that the application shall be filed in the time period, and it gives a date range of July 2nd to September 15th. The applicant, unfortunately, was 1 day late, and the board does not have the authority legally to accept a late filed application under this circumstance. The applicant can, next year, for the next lien date, the applicant can make careful note to go in before the deadline and file promptly and not wait until the very end and then can pursue appeal rights for the future. But for this application year, I agree with the chair's assessment that the board doesn't have authority to grant relief.
Much as we might.
Well, thank you
feel
for your time anyway.
Do you have anything you want to tell us or argue? But it seems pretty clear that we don't have that kind of authority, much as we might like to or not.
I'll probably just wait on the proper date or something. Sorry that I apply late or something. But my for being here is to, I only gave you a few of these so I won't bore you, but I think they should reconsider my brother, property on 177 Cartagena, because the tax is too high. And when it was transferred in 2003, there's no money involved. It was just a name, transferred, to him. We didn't sell that property or anything like that compared to those other, in the area. So that's all I can say. Maybe I could appeal it again next time since I was late, but I thought you could reconsider it since, I'm asking.
Like I say, if we could find a way, we'd consider it, but it doesn't appear that we have that authority to be able to do that.
Okay, but I could go ahead, appeal it again in July or in September?
Correct. You can appeal between July 2nd and September 15th.
To September 15th, right?
Right.
Yeah. Okay.
So don't wait to the very end, I guess is the
Thank you very much for
if
your
the
time.
assessor could interject, ma'am, it may be beneficial to you to speak to Mr. Denham on your way out. I know you don't have a valid appeal at this point, but we're happy to discuss with you. And looking over your application, I believe we can at least come to a mutual understanding so you can better understand the property tax process. Okay. The ladies back here can help you find Mr. Denham. I believe he's out in the lobby.
Okay.
Okay.
Thank you very much.
All right, thank you for coming.
Thank you for your time.
Our pleasure.
So board members, we would be looking for a motion in the ballpark to reject the application as untimely filed.
So moved.
I second.
Please vote. Thank you, that motion passes. And item number 99, application number 1511561, applicant Telos Development of Ojai LLC, FKA Telos LLC, Robert Martin. I'll go ahead and hand out some materials. Just real quickly, the applicant's representative is not here today. We're not certain, because it's not a valuation hearing, there's not really any technical rules as if the applicant has to be here or not. So we informed the applicant we would present their letter, and so the applicant has requested first a postponement of this validity hearing. Sorry, if I have all the materials in date order. If you would go from the back. Okay, there's a rescheduling request 4 pages from the last. I have it marked rescheduling request late at the top.
Was that the April 20th letter?
Yes, the letter is dated April 20th, 2016. And my response to that follows. So I'll just go over my response because it kind of covers. So on April 20th, the this is the applicant. The applicant requested a postponement. They were 2 days late from the legal requirement to request a postponement without having to appear in person, so the clerk hands were tied. We couldn't grant a postponement. We gave them notice of validity hearing on March 11th, 2016, giving them 59 days advance notice of the hearing, giving them plenty of time to make arrangements and or request rescheduling. As I state or highlighted in my April 25th letter, it says the clerk of the board will present your letter to the Assessment Appeals Board on May 9th, and the board will determine whether or not to grant your request to continue the matter to a later date. I don't believe it would be necessary for the board to postpone. The applicant, I spoke with the applicant, and they said pretty much all the evidence is provided here in writing as far as their validity issue. And so I think it would be most appropriate for the board to deny the request for postponement and then review the additional information, which I can go over, which addresses the application validity. So I believe what the board can take action on the postponement request now, or we can go and cover all the issues the additional information related to application validity, and then the board can decide if they want to hear more from the applicant and then grant the continuance postponement, or the board can take action to deny. It's kind of up in whatever the board's preference is. Our preference as the clerk would be to get this taken care of right now, as I believe there's sufficient information within the packet for the board to determine the application's validity. So depending on the board, if the board can either entertain a motion regarding to the postponement, or they can direct me to go into more information about the validity issues.
It's at the board's discretion whether they wish to entertain the request for postponement or wish to go directly to the issue of the validity of the application. For purposes of challenges, on due process grounds, the board's perhaps on a stronger ground if it considers the applicant's request for a postponement and makes a ruling on that first, even if it then proceeds to the second ground.
I think adequate notice has been given to the applicant 59 days in advance.
They had ample time, yeah.
All right, so if we take up the postponement issue, we're looking for a motion to either grant the postponement or deny the postponement. If we deny the postponement, then we take it up at this point? Is that how this works?
Correct.
All right.
I have the agent, as you'll see in the materials, as a response to me denying their request, they provided additional letters. We informed them we would provide the board with anything they wanted to give us in writing. And talking with him on the phone, he doesn't believe there's much more information that could be provided. Really, the only we wouldn't have a person to question and testify under oath as to these facts, but under the laws, all these documents submitted are true and correct as submitted, so they would have the effect of testimony under oath, basically.
Bit of a catch-22.
Yeah.
I don't like not having the applicant here.
It's interesting, his letter of, the applicant attorney's letter of April 28th talks about him being present today.
So I guess the applicant stated their reason they could not be present today is because they made travel arrangements to visit their daughter in New Orleans, so it wasn't really any type of emergency situation where we could excuse the lateness of the request. So I made the applicant fully aware that we were denying the request, and that we were going to request that the board determine the issue of validity today. So they're aware of the issues. They chose not to appear today.
Council would like to interject. The applicant missed the request date by 2 days for the continuance of the hearing, but the circumstances are such that the applicant has made travel arrangements to visit, I don't know where the daughter is, but a family member, presumably in another city far away. From a standpoint of the merits, when the board addresses the merits of the validity hearing, if the applicant has had an opportunity to be personally present, even if the applicant later hypothetically is found not to satisfy the deadline, I think the applicant will have felt that they've received their full chance to at least present their case to the board. And that's just something I want the board to hold in mind. It's at the board's discretion.
The clerk believes that we have enough information in our file here to make a determination on the validity.
Yeah, if the board would like to hear all that before determining on the postponement. I mean, the board can hear all the evidence and decide they're going to continue and give the applicant a chance to be present. I can go into that now. it's at the discretion of the board.
Any comments from the board members or other board members, or a motion one way or the other on this one?
I have a verbiage question. Does our filing time say must be mailed by a certain date or received by a certain date?
It's
September 15th.
Right. That would be in Property Tax Rule 305. It should have it marked here in your packet. And then it's highlighted actually on page 3 of Rule 305, D, time of filing. Let's cover that. And that the rules require the application to be postmarked by September 15th, and it says if let me see. Okay, and then section 5 on the next page, it says an application will be deemed to have been timely filed if it is sent by U.S. mail, property address with postage prepaid, and postmarked on the last day of the filing period or earlier. So this is saying that it has to be postmarked, and B actually said, is it B? No, section 6 actually addresses the private postage versus the U.S. Postal Service postage, and it says we have to go off the U.S. Postal Service postmark. And so, as far as the postmark and the filing period timeline goes, we're saying because the envelope was stamped by the U.S. Postal Service as September 16th, that it was not timely postmarked. However, this one falls into a special category.
Excuse me, Mr. Villahakis, I think the rule that matters here wasn't highlighted in your paper.
Right, I was going to mention that.
Subsection B, let me backtrack here.
Right, that's what I was going to address next.
There's a two-pronged test. An application will be deemed to have been timely filed, one, if you've got the postmark by the deadline, or, and it says or, B, if proof satisfactory to the board establishes that the mailing occurred on the last day of the filing period or within such period. Any statement or affidavit made by an applicant asserting such a timely filing must be made within 1 year of the last day of the filing period. So either the postmark or the board finds proof satisfactory to it that the person went to the mailbox, bought the stamp on the 15th, and went to the mailbox and dropped it in that hatch prior to 5:30, which was the posted time for collection on that day. And there is an affidavit there where the person says she's certain she dropped it in before 5:30. She believes it was between 5:15 and 5:20. So if the board finds that affidavit satisfactory, then the board can find that it was timely mailed and filed.
Right, yeah, that's what I was going to address next. Is as part of the applicant's packet, which council just said, that is in here, they are stating that it was dropped in the mail. And so really the uncertainty is when it was actually dropped in the mail versus when it was postmarked, and it's at the discretion of the board if they want to accept the applicant's affidavit that they did timely file it. That's kind of, as council said, up to the board to weigh, because there's that period of uncertainty. I did ask them if they had any proof of mailing or receipt, a certified mail receipt. They indicated that they didn't do anything special. They just dropped it in the mail, and that their affidavit here was the only proof.
Legally, the board does have the authority, if it's persuaded by the affidavit of Tracy Lynn McFawn, to accept this as of, having been filed on September 15th, if the board finds that affidavit satisfactory. It's up to the board. Or the board can wait and ask for a live person to come and address these issues if they want to do a credibility assessment in person. It's at the board's discretion.
I don't know that having the Mr. Martin or somebody else appear is going to change their assertions as stated in the declarations and that accompanied the letter of whatever it is, December 18th.
But we also do have the postage log from the company.
But there's no guarantee of when she dropped it off. She could have dropped it off at 5:35.
Exactly.
Well, what's the board's pleasure?
So, Matt, if this board feels that there are circumstances that show that it could have possibly been mailed timely,
Right.
Our motion would be
To determine that the application was timely filed and accepted as valid.
I'm actually comfortable with that. The other board members are comfortable with that.
Me too.
Just for, I don't know if we need to ask if the assessor's office has any statements.
The assessor has no comments. Thank you, though.
Sorry.
okay.
So the appropriate motion would be, given what we've indicated we want to do, would be to...
Right. So what I understand the board is looking to do is for one of them to make a motion to accept the application as valid and timely filed.
So moved.
I second.
All right, please vote. All right, thank you. That motion passes and the application has been reopened. All right, next we have item number 100. We're almost done. Hearing officer decisions for the meeting held Tuesday, April 26, 2016, items 101 through 136. The board is Assessment Appeals Board is required to just receive the Assessment Appeals hearing officer's actions for the record. So this will be a blanket motion. Just the board just needs to receive and file the hearing officer's decisions. They were provided by the board to the board by email. However, the hearing officer's decisions are final and can't necessarily be overwritten by the board. So really, I think the board's only option is to receive and file.
Okay, I have a question. In the past, we've used the verbiage accept and file. Are they interchangeable, receive and accept?
I would not recommend accept because that would imply that the board had some authority over the hearing officer's decisions, which they don't. They just have the authority to receive for the record the hearing officer's decision, unless
Okay.
counsel has a difference of opinion.
I'm being technical today. Move to receive and file the hearing officer's decisions.
Is there a second?
A second.
And those have been received for the record. All right. And next we have item number 137, stipulation agreements, items 138 through 160. Is it review and approve without discussion unless an item is pulled by the Assessment Appeals Board for separate action and moved to the regular agenda for discussion and consideration. So these are all up for a blanket approval unless the board wishes to call one out for special discussion and or questioning from the assessor.
I received these via email. I'm sure the other board members
Yes,
did.
I reviewed them too.
Okay. I move to approve the stipulations.
Any comments from the assessor?
I second.
Been moved and seconded.
Thank you. Please vote. And the stipulations have been approved. Unless the board wishes to go back to any particular item, the board is free to adjourn the meeting. The current time is 11:46 a.m.
All right. Anything further from anybody? We are adjourned.
Sorry, and I think it's 10:46. I think I misspoke and said 11. So it's 10:46 a.m. and the meeting is adjourned.